Welcome to Kanooni Charcha. Today for discussion is the topic, title of the topic is Revisional Jurisdiction. How to be exercised, what are the courts who can exercise the criminal jurisdiction. Under earlier the relevant provision was 397, under which Court of Session exercises its jurisdiction. And similarly, the Hon'ble High Court exercises similar power of revision while invoking its jurisdiction under section 401 of Code of Criminal Procedure. These provisions are no more applicable in future. These proceedings after 1st of July, now there is a BNSS. Corresponding provisions which are relating to the jurisdiction of a session to revise a order of subordinate court in court of this magistrate's court, you may say. That is now 441. And the next powers of Hon'ble High Court of revision under BNSS is to be dealt with 442 of Code of Criminal Procedure. This I have told you, mentioned here, that the revisional jurisdictions only are exercised, I will repeat, by Court of Session and Hon'ble High Court only. Now, next question is, what are the area of revision? I will in short tell you in order to check the propriety, legality, and this and of proceedings. With the proceedings are, there is no irregularity in proceedings. This is illegality, impropriety, and this propriety. These three grounds can be invoked. The jurisdiction of revision can be exercised by the revisional court suo motu at its own when some the order comes to their knowledge. This is with regard to High Court. If High Court comes with regard to some order which is according to them and it is reported, or otherwise they came to know that it is not in accordance with law, then there is a illegality, impropriety in the order, then the Hon'ble High Court can exercise jurisdiction at its own. Now, a relevant case which I am interested to blab upon, very important case. This is a case of having title C.N. Santha versus M. Shri Nivas. This earlier SLP was filed before the Supreme Court of India, but it was converted into a criminal appeal. It was related earlier. What are the facts which given rise to this criminal appeal? Are a complaint was filed before the trial court under section 138 Negotiable of Instrument Act. Check dishonor case, you might be knowing. The accused was convicted and simultaneously sentenced. After that, obviously, the accused has to go into an appeal because he aggrieved of the order. He went to Court of Session by way of an appeal. This is this appellate court, Court of Session, acquitted the accused, reversed the finding of the trial court. Thereafter, obviously, complainant went into this revision petition in terms of section 397 of this, not 397 because 397 relates to the power of the session judge, but under section 401 of Code of Criminal Procedure. I have already mentioned that sections relevant under which this is related to Code of Criminal Procedure, which these provisions are applicable to the earlier proceeding because those were taken before 1st of July 2023. Now, under 401, a revision was filed before the Hon'ble High Court. But High Court does, in short, High Court reversed the finding of the this appellate court. Appellate acquitted, earlier acquitted the accused. Now, the order of acquittal was converted by the Hon'ble High Court while exercising criminal jurisdiction. This criminal revision, while exercising criminal revision powers as vested, I have already told you, 401. Now this order of conviction, conversion of the acquittal to conviction, the Supreme Court was approached by the by this accused by of this SLP. I have already mentioned that it was converted to criminal appeal. Now, what I have verbally mentioned about the brief facts of the case. This is, I have mentioned that earlier, this is para 3, which relates to the facts, how the accused was convicted by the trial court and went in the other side, complainant went into appeal, and not complainant but accused, because he was convicted. Accused was, he went into appeal and the order of his conviction was overturned and he was acquitted. Thereafter, this revision petition was filed under section 401 before the Hon'ble High Court. This is the para 4 you will find. My concern is, now this question, moot court question, which I discussed in this judgment order of the Supreme Court, whether High Court, while exercising jurisdiction, can convert order of acquittal into a order of conviction. This is for the order of Supreme Court is not detailed, but I want to add in order to make you understand that section. I am going to particularly directly to section 401 of Code of Criminal Procedure, High Court's power of revision. This is para 1 is, I have already mentioned, a discretion can be exercised by the court, Hon'ble High Court at its own, can revise for revising any order, and otherwise they can hear the revision petition. But I am mainly concerned about subsection 2 and subsection 3, which are, subsection 2 is relevant, but subsection 3 is more relevant, which is applicable into this case. Now, I will read subsection 2. No order under this section shall be made to the prejudice of the accused or other person unless he has had an opportunity of being heard either personally or by pleader in his own defense. In the this section is based on principle of natural justice. Opportunity of being heard is to be given to the accused by making any order or was to him. Though now the specific section which is involved in this case, I have already the Supreme Court of India. This is very relevant. I will read, then I will discuss further. Subsection 3 of section 401 of Code of Criminal Procedure. This is, nothing in this section shall be deemed to authorize a High Court. High Court is not vested with, cannot exercise power for to convert a finding of acquittal into one of conviction. This is subsection 3, which is very relevant, which is dealt with I'm going to read further the judgment here. Now I will read subsection this 4 also. This is relating to when there is no appeal against a particular order, then there is no revision. No revision. If somehow there is the appeal available and somebody has filed revision, so where the Hon'ble High Court is having power to convert that revision into appeal. This is subsection 5 also. Now subsection 5 also. Now I will go to directly to para 6 of the judgment of this. I have already referred this judgment of S.N. Santha versus M.S. Shri Nivas, and our justices who there were 2 bench this Justice Shri Harkesh Rai and Justice S.B.N. Bhatti, the 2 judges who have authored this judgment, and this Shri appears the now para 6. Whether a particular case merits conviction or not is not the issue before us in the present proceeding. There is no, we are not supposed to go into detail of the not go to see the merits, see the evidence or other things. Only question the subsection 3 of section 401. I have already read this section for convenience of this episode or for your viewers also. Clearly says that High Court does not have the authority to convert a finding of acquittal into one of conviction while exercising its revisional power. This is a para specific para. What that precisely was done by the High Court under impugned judgment dated 19th of January 2023. Now, this order has been assailed, order of converting of this order of acquittal into conviction by the Hon'ble High Court. Now, specific section has been interpreted by the Lordship and drawn a conclusion. I have also read that section, that exercise made by the High Court is not in accordance with law, statutory provisions. Now, para 7 here, I will read it also. The impugned decision of High Court is therefore found to be unsustainable. This is observation finding given by in this judgment. If High Court was convicted about a wrongful acquittal, if the High Court was convinced, sorry, not convicted, but convinced about a wrongful acquittal, the High Court in revision could not have ordered for conviction. It ought to have remitted the matter back to the appellate court to reappreciate the matter. This course was not adopted. The Hon'ble High Court or revisional, I say any revisional court cannot find its independent finding. If there is a legality, impropriety, and order is not found in accordance with law, the revisional court has to record its finding and send back the case. Order it to be passed by the court against whom the order revision is being heard by this revisional court. So now appellate courts, if they have recorded a finding that this order was not in accordance with law, there is an impropriety or illegality in order, the best course as per these provisions or otherwise the Supreme Court has guided that the case must have been remanded, and there must be a direction that it would be decided as per their guidelines, but it has not been done by the Hon'ble High Court. Having considered, this is para 8, I think it is a crux of the operative part of the judgment. Having considered the above, we deem it appropriate to remit the matter back to the appellate court, meet additional district and session judge at Bangalore, rural district, and call. Both the parties were should appear before the said court within 4 weeks from today, and appropriate decision should then be rendered by the appellate court or after considering the contentions of the rival parties. It is ordered accordingly. Means what happened? The Hon'ble Supreme Court of India set aside virtually the order of this High Court and remanded back the case to the appellate court for deciding the appeal on its merits. Now, with this the matter stand, appeal stand, discrimination stand, appeal. In short, crux of this judgment is that a Hon'ble High Court in this particular or subsection 3 of section this 401 CRPC provides that corresponding is 442 of BNS, provides that no order of acquittal passed in appeal or otherwise can be substituted or otherwise converted to conviction by Hon'ble Court while exercising revisional jurisdiction. This is crux of the judgment. So then I have found this judgment, and it is a very recent time. So I thought it that I will share with you accordingly I have done. Thank you, sir. Thank you. Thank you.